Assalamu alaikum. In our previous lecture, we were discussing some global legal issues and we had discussed the concept of territorial jurisdiction, then online contracts and copyright issue over the internet. Let's revise a little bit what we had discussed. Territorial jurisdiction means the competence of a court to decide a case based upon a certain territory or area. So you are familiar that if a dispute arises in Lahore and there is no connection of the transaction with any other territory in Pakistan except Lahore, then the courts in Lahore, they have the jurisdiction to decide such a case. In cyberspace, the concept of territorial jurisdiction becomes very complicated. So you may have noticed that there are different countries which emerge, which come into picture in case of a internet dispute, and therefore the question arises as to where the case should be filed. So there are different countries having different sets of laws. There may be conflicts amongst different set of laws in different countries, and there is no international forum as such where a matter has to be taken. Gradually, courts have established different principles. So one basic principle is that country should have the jurisdiction, the court in that country should have the jurisdiction which has some significant relationship with the transaction. So, for example, where the effects of an internet activity reach that territory, the court belonging to that territory may have jurisdiction to decide an internet dispute. Then we talked about the online contracts. Remember, I told you that to establish a valid contract, 3 ingredients must be satisfied. What are those? Offer, acceptance, and consideration. So the same 3 ingredients or elements must be satisfied in case a valid online contract has to come into existence. And we had discussed at length what is the significance of offer, acceptance, and what does consideration mean. Then copyright. Copyright, if you remember, is the exclusive right of an author of an artistic or literary work to publish, reproduce, or make copies of that work. If anybody without the permission of the author reproduces, copies, or publishes his original work, then he can be termed as violating the copyright of the author. Then we talked about the fair use or fair dealing concept, which creates an exception to copyright. So by protecting one under the fair use or fair dealing clause, one can escape the copyright liability, and there are certain circumstances we had discussed under which the protection of fair use can be established. In our today's lecture, we shall talk about the concept of patents, then the conflicting areas between the trademarks and domain names. We'll also discuss the privacy issue on the internet and the concept of online defamation. And we'll also talk about briefly the issue of cyber crimes. What is meant by a patent? A patent is defined as that exclusive right of a person which allows that person to make or use or sell an invention. Okay? So wherever somebody has made an invention and he gets a patent in relation to that invention, then that individual has the exclusive right of using or selling that invention or making that invention, right? When certain software tools or packages were developed, the software companies, they very eagerly went for the registration of their patents as regards those software tools or packages. But later they realized that this exercise is proving to be very expensive, and at the same time it is quite time consuming. So the patenting of software tools is not that popular an option. On the other hand, we can register copyright in relation to software packages or tools. Patents are not that popular an option. However, interestingly, there are business process patents which are quite popular. Okay? A business process patent would protect the method of doing a particular business. So if we have different sets of procedures we have prescribed for doing our business, and we register our patent in relation to those methods of doing business, then we can say that we have established a business process patent. It has been quite popular. So there is a famous online business which had introduced a unique one-click purchasing method, and it created a patent in relation to this unique purchasing process. Similarly, there is an example of an online business which had introduced a unique price tendering system. So using that, the customers could name their own price. Again, that business got a patent in respect of that business exercise. Similarly, there is the example of another online business which used an approach which allowed it to aggregate or assemble different types of information from different websites, and it again got a patent in respect thereof. There are certain experts which say that on one hand the business process patents, they are quite useful, but on the other hand they cause an unfair monopoly of those which have introduced such business processes, right? So they argue that business process patents, they should be restricted. I may point out here that there are quite a few cases which are pending in the courts abroad which exclusively deal with the business process patents, and the courts are busy in deciding such matters. They are busy in establishing various legal principles in relation thereof. There is no time for us here to debate on that. We just need to have this broad concept which we have discussed. Then online defamation is again a huge area of concern over the internet. What is meant by defamation? In simple terms, defamation means injuring one's reputation, right? So if there is a false statement about a person which injures that person's reputation, and we use the medium of internet to cause such injury to one's reputation, then we can say that online defamation has been caused. It's an offense, and the courts abroad, they are replete with cases related to online defamation. One basic reason is that you can expect to remain anonymous over the internet. The nature of the internet technology is such that it is not likely that you would be easily identified. So that has given rise to the cases of online defamation. Okay, then there is a term fair comment which is used in this concept. I'll give you an example. Say there is a doctor who is incompetent, and you publicize this information to the public at large that, well, this particular doctor, he is totally incompetent, and that doctor brings a civil suit against you, claiming that you have caused defamation, you have injured his reputation. Then as a defense, you can raise the plea of fair comment. You can come and argue that, well, whatever I have stated about this doctor, it is not wrong, it is a well-established fact, it is not a false statement, it's a fair comment. So, mostly in cases of defamation, the defense of fair comment is pleaded. Similarly, in case of online defamation, the same plea of fair comment is normally raised. Okay, then while designing your websites, the designers of the website, they should be very careful about this thing, that the images or the pictures which are being applied on the website, they should not alter or distort the image of a person. Similarly, if you are making some comments about your competitors on a website, then you should be careful that your comment should not unfairly injure the reputation of your competitor. So all such negative statements or evaluative remarks, if you want to throw them over the internet, if you want to use them over the internet, you have to be careful about this issue of online defamation. There is a very interesting phenomena of the ISP liability in relation to the cases of online defamation. Okay, so one argues that, well, the individual who has caused online defamation, that individual may not be caught because of the nature of the technology, but the ISP which has provided services to that individual, that ISP is easily locatable. So why not catch that ISP and make that ISP liable for online defamation? Here the courts have identified a test, and normally this test is applied while deciding such cases as to whether the liability of the ISP is attracted or not. And the test is that you have to see whether the ISP is acting as a publisher or as a distributor. Okay, so wherever the ISP which has provided the facility to an individual, that ISP has the editing control over the content, and it is in a position to take down any offensive material from the website, then that ISP is dubbed as a publisher. In other words, it may be said to have aided in the commission of the online defamation. On the other hand, if the ISP is just providing a communication channel to its customers, it has got no editing control, it is not in a position to take down any offensive material from its website, then that ISP is said to be acting as a distributor. And if the ISP is a distributor, no contributory role is attributed to such an ISP. The ISP would not be then liable. Okay, then the trademark and domain name conflicts, these are huge issues over the internet. So let's see what are the various conflicting areas dealing with domain names and trademarks. First of all, let me define what a trademark is. A trademark is that symbol which associates a product with the manufacturer of that product. Okay? And whosoever has got a trademark, he has got the exclusive right to use that trademark in relation to its products. If anybody else uses the same trademark, then it may be said to have infringed the trademark rights of that person. So I'll give you an example. Say, if a firm, it uses letter U in a particular style, and that letter U is written in a circle, and this symbol is affixed on the packaging of each product of that firm, then that firm can claim that it has got a trademark and nobody else can use this trademark in relation to the same products. Okay. On the other hand, domain names, they are user-friendly names, and using these user-friendly names, one can access the websites. So these are the part of the URL. Now, what are the areas of conflict? Experts have identified that there are mainly 4 conflicting scenarios between trademarks or trade names and the domain names. One is cyber squatting, the other is related to concurrent use, the third is parasites, and number 4 is in relation to the use of second level domains in different top level domains. So we'll see them with the help of examples. I have prepared 2 slides in this regard. You can look at the screen. Cyber squatting is the act of intentionally registering domain names containing trademarks of prominent companies to demand ransom from those companies. It means that in case there is a prominent company, assuming its name is Glory Enterprise, and that company is known for its products, for its services, and that company wants to have online presence, and it goes for the registration of its domain name in order to access its website, and it intends to have its trade name Glory appearing as a part of its domain name, then it may discover that already someone, say Mr. ABC, has registered this domain name glory.com. Now, domain names, they are unique. There can't be 2 domain names having the identical words or identical names. So, when that company, Glory Enterprises, contacts that Mr. ABC and asks him to transfer this domain name to the said company, it may find that Mr. ABC is blackmailing the company and it is asking for certain money, certain ransom for transferring that domain name to the genuine user of it. So once such a practice is being carried out, that is called cyber squatting, and the person who claims ransom and he in this way blackmails the original company, he is called the cyber squatter. Remember, the cyber squatting is considered as a legal offense in most jurisdictions. There are anti-cyber squatting laws in place. Then concurrent use. This problem arises when 2 organizations have apparently legitimate claim to use the same domain name but cannot do so due to uniqueness of domain names. For example, there are 2 companies and both have their trade names starting with the word fry. and whenever they want to have their online presence, they want a domain name, there is a conflict between their claims. Both are legitimate claimants. One company using the word fry does its business in relation to electronic goods. The other company is the maker of, say, French fries, using the word fry in relation to its product. But since the domain name can only be one, the domain name is unique, so the legitimate claim of both these companies cannot be satisfied. This is because the trademarks or trade names, they are not global in nature, they are localized. Same trademarks or trade names can be used with different products in different geographical areas. On the other hand, the domain name is unique, it can only be one, so therefore this problem arises. And then the court has to decide as to which company has a better right or a more legitimate claim. Then the third area of conflict is with regard to parasite websites. Parasite domain names are variants on famous domain names, being confusingly similar to them to gain business advantage. An example is Macrosoft.com. So instead of Microsoft.com, which is a famous company, if I vary the domain name of the famous company Microsoft, I vary it as Macrosoft, then in fact I am trying to take business advantage of the name of Microsoft. I deliberately keep my domain name confusingly similar with the name of the famous company Microsoft, and in this manner I try to take a competitive advantage. So wherever it is possible that you change a few letters in the domain name and you make your domain name confusingly similar to the name of a famous brand, then that website can be termed as a parasite website. The fourth example of the conflict between the trademarks and the domain names is in relation to the example xyz.com versus xyz.org. This problem arises on account of the fact that second level domain name can be assigned to multiple top level domain names. For example, whitehouse.com versus whitehouse.org. In fact, whitehouse.org may be a website that deals with the information about the residence of the American president. On the other hand, deliberately, one can create a domain name which has the second level domain as White House, and it is registered in the top level domain .com. This is permissible, this is legal otherwise, despite the fact that the person is deliberately trying to make use of that popular domain name whitehouse.org. And it is possible that a user just types White House and he finds the whitehouse.com website at the top on the ranking when he uses the search engine, and by clicking the URL he reaches a website which is totally irrelevant, which may be an obscene website, although that person had intended to find out the information about the residence of the American president. So in this way, deliberately, a domain name is registered which resembles to the domain name of a famous website, and it is registered in a different top level domain just to gain some advantage. Okay, these are the four basic areas of conflict between trademarks and domain names. Remember, I can International Corporation for Assigned Names and Numbers. You are familiar with this name. ICANN has the supervisory role as regard the registration of domain names worldwide. And ICANN had introduced a policy called Uniform Dispute Resolution Policy, UDRP. So this policy aims at the resolution of conflicts or disputes between trademarks and domain names. Under the UDRP, or the Uniform Dispute Resolution Policy, a trademark holder can retrieve or claim his domain name by applying or by invoking the mandatory arbitration proceedings which are conceived under the UDRP. Okay. So if somebody has a claim that it was his domain name, it should be assigned to that individual, that under the UDRP a claim can be filed before the arbitrators, and then they make a decision as to whether this domain name belongs to this man or not. You should know the concept of arbitration. It's a legal concept whereby two parties through an agreement can decide that in case any dispute arises between them, then instead of filing the case before the ordinary court of law, they would refer the matter to a nominated person. They nominate that person normally in the agreement itself, and that person would act as a judge and he would decide that dispute. That person is then called an arbitrator. The decision of the arbitrator is final, it is binding between the parties. So the idea behind arbitration is that you save your time. Instead of going to the ordinary courts, you have an exclusive forum, and the arbitrator then makes a decision in case of your dispute. There are 4 arbitration service providers which have been nominated under the UDRP. One such arbitration service provider is WIPO, World Intellectual Property Organization. You are familiar with that name. Okay, then let's talk about the issue of online privacy. The issue of online privacy is evolving since the time internet has emerged as a tool of communication and commerce. So the nature of the technology is such that on a website one can collect the personal data, personal information of the customers. One can view the habits of the web usage of different customers, their buying pattern, their product selection, their demographic information such as the age, sex, location, etc. All this information can be recorded in the databases on the merchant side. Now, this gives rise to the problem of privacy. People, they are quite apprehensive about this thing that their secret, their private information can be rented out, can be sold out to the outside world, to the third parties. So there should be legal protective mechanism to support them or to safeguard their privacy. Remember, different cultures, they have different norms as regards privacy. So the expectations of privacy rights, the safeguard of the privacy rights, they are different in different cultures. Some countries, they have enacted full-fledged privacy laws, whereas such laws are still missing in other countries. In 1998, European Union had adopted a directive on the protection of personal data or personal information, and it attracted the attention of a lot of people. The directive basically aims at providing the safeguard for the privacy of the individuals. So in most European countries, there are constitutional guarantees that the privacy rights of the individuals would be safeguarded. So these constitutional guarantees, in fact, were codified in the shape of privacy law. At the same time, this directive also declared that wherever any personal data of individuals is exported to the other countries, then those countries, they should safeguard the privacy rights of such individuals. They should have proper legal mechanism which is in line with the provisions of the directive, and whereby the information exported to such countries is properly safeguarded as it is safeguarded under the provisions of the directive. Okay, then there are countries which have not made any privacy laws as such, and they have chosen an open policy. In fact, instead of having any government regulations to prescribe the measures for protecting privacy, they have conferred the responsibility upon the individual companies to prescribe their own adequate policies for the protection of privacy. So America is one such country. America has in fact used two different approaches. One is opt-out approach and the other is opt-in approach. And the idea is that the companies should themselves adopt any of these approaches through their policies. In the opt-out approach, the companies, they assume that whatever information they are collecting from the customers are giving their consent to the companies that any such information can be supplied to the outside world, to the other firms. So this information can be rented out, it can be marketed, it can be sold out to any third parties or any other firms, unless the person specifically says that his information should not be passed over to any such outside firms. So as long as the person does not indicate that his information should not be used, the companies can adopt a policy whereby they can supply this information to the third parties. On the other hand, in case of opt-in approach, which is less popular, less common as compared to opt-out approach, the companies adhere to a policy whereby they say that, well, they assume that the information the customers have provided, that information would not be sold or marketed or rented to any outside firms unless that person himself chooses for that. If in case that person himself says that, well, there is no problem, you can sell, you can market, you can rent out my information to the outside world, these companies would not make use of any such information for purposes other than the ones prescribed by the customers themselves. The experts have identified that there are 4 guiding principles whenever any legislation will have to be made to safeguard privacy, informational privacy of individuals, then these 4 principles must be considered. What are these principles? Number 1, the information collected from customers, that information can be utilized to improve the customer service. Number 2, don't share this information with any other firms unless that person whose information it is, he himself declares, he himself says, or he himself consents that, well, this information can be passed over to any third parties. Third is that the customers whose information is being collected, they must be told that, well, your information is being collected, such and such information is being collected, and this information is being used for such and such purposes. And the fourth guiding principle is, which a legislation should consider, is that the customer should have a right to ask the company to delete any information which the company has collected. So these are the four broad guidelines which can be considered while making laws on privacy. Okay, next I would like to talk about the taxation issue over the internet. First thing you should keep in mind is that all those principles of taxation which are applicable in the traditional physical world to the companies, all such principles are also equally applicable to e-businesses. Right? So, whatever taxes, income tax, sales tax, customs duties, all such taxes which are applicable in the physical world, they would also be applicable to the online businesses. However, things get complicated in the cyberspace because different countries, they are coming into picture, they have different set of laws, these laws may be conflicting with each other, so this makes the situation quite complicated. For example, in case you have established your business and in the physical world, and it has been established at a local place and within a geographical area, then you are subject to a single set of laws which are enforced in that particular geographical areas. On the other hand, in case of online businesses, since the entire world is a potential customer to your business and different countries have different set of laws, therefore the taxation laws, the set of taxation laws which are enforced in different countries, they would automatically be applicable, or their application can be considered in relation to your online business. So this makes the situation quite complicated. Now, what are the different taxes which are to be levied or which are to be paid in case of online businesses? These are mainly, number one, income tax, number two, transaction taxes, and number three, property taxes. Income tax is the tax which is levied on the income of a company which may be generated through a business, and it is to be paid in the country where the business is located. Sales tax is a type of transaction tax, and it is to be collected by the customers and it is paid by the seller. Then another type of transaction tax is in terms of custom duty. Custom duty is levied on the import of items into a country. Property taxes are those taxes which are related to the use of property, including the real estate, the land, etc. And these taxes, they are to be paid to the government which is associated with the particular internet activity. Out of these taxes, the income tax and the sales tax, they are the more important ones. There is a concept of nexus. In order to decide as to where the tax has to be paid, the concept of nexus should be clear in your mind. The government acquires the power to levy tax on the customers wherever the business has established any connection with the area which is controlled by that government. Right? So, connection between the tax-paying entity and the government is called the nexus. So, in order to determine where the income tax has to be paid, first of all, the nexus would be identified. And the general principle is that where there is a significant or sufficient business activity being conducted, the country where sufficient business activity of an online business is being carried out, that country would have nexus, and the tax has to be paid under the laws of that country. The return has to be filed under the laws of that country in case of online businesses. Okay, here let me point out that in case of online businesses where you have maintained a website, that place should be considered for the payment of taxes. So if a website is maintained in America, then the income tax has to be paid under the laws of America. And for the income that you have generated from the business which you conducted in America, as well as for the business that you have generated outside America. However, where you have paid tax in certain other countries for business which you generated outside America, then the American law permits that you can get the credit of any such tax. You don't have to pay such tax to the American government because you have already paid that tax to that other country government. Right? In case of sales tax also, the determination where the sales tax has to be paid would be made based upon this thing, that where the customer is located and what are the laws within that particular jurisdiction that deal with the sales tax. And the last main legal issue that I would like to discuss with you is the issue of cyber crimes. So there are certain crimes or offenses which we had not thought of earlier, and they have cropped up because of the advent of electronic commerce and the use of internet. There are certain novel legal issues or crimes which have emerged. For example, online fraud, forgery, cyber stalking, which means threatening persons using the internet, then the distribution of pornography and using computers to launch attacks on other computers, etc. These are all different offenses or crimes, and they are generally called as cyber crimes. Now, different countries, they are busy in enacting criminal laws which define these different crimes, and there are countries which have already got the criminal code and they are amending their criminal code and they are incorporating these novel offenses, crimes in their respective codes. Again, the issue of jurisdiction would be very important when you are dealing with cyber crime. So in case there is a Pakistani who commits a crime which is considered as a crime in Canada, say he commits a crime against a person who is living in Canada, then the question would be that whether the Canadian police has the right or the Canadian courts have the right to take any action against that Pakistani individual, because it is quite possible that in Pakistan such an action is not a crime. Right? So there are certain complicated issues which emerge in this background. and the courts are laying down different tests. They are busy in determining different principles. It would be decided basically on case-to-case basis. So that was the discussion broadly I wanted to have with you in relation to global legal issues. Let's revise what we have done in our today's lecture. We have basically talked about the concept of online defamation. And I told you that online defamation is making false statements which injure the reputation of a person, and it is generally believed that using internet one can easily do online defamation because one can expect to remain anonymous because of the nature of the internet technology. And then there is the issue of ISP's liability in cases of online defamation, where an ISP is acting as a publisher, it has got the editing control, the ISP may be held as liable for online defamation. And where it is acting just as a distributor, it is just providing a communication channel, there it cannot be held liable. Then online privacy, again it's a huge area of concern over the internet, and there are full-fledged privacy laws which have been enacted in various parts of the world, and they have guaranteed the protection of privacy rights of individuals. There are other countries in the world which have chosen to adopt a loose policy, and they have not put in place government regulations in this regard. Rather, they have entrusted the tasks upon the companies themselves. So the companies on their own, by making their own policies, they aim at protecting the privacy of the customers. So there are two approaches which are used in America: opt-out approach and opt-in approach. I just discussed with you. Then the issue of taxation. Again, since there are different countries which are coming into play, and this is the difficulty that different countries, they may be having different set of laws. In fact, these laws may be having conflict with each other. So therefore, the problem arises as to which is the court where the matter can be taken, and which is the taxation regime which has to be followed. And again, there are different taxes which are applicable in the physical world. All such taxes are also equally applicable to the online businesses. So there is the income tax, the transaction taxes, which include the customs duty and the sales tax, and then there are the property taxes. These taxes can be levied and they can be collected by different governments. I told you about the concept of nexus, so which means that wherever an online business is having a sufficient business activity, then there is a connection of that online business with that particular country, and then the taxation laws enforced in that country, they would automatically be applicable. So under such laws, then the income tax returns or sales tax returns have to be filed by the businesses, and the tax has to be remitted there. Okay, then in the end we discussed cyber crimes. So I mentioned that online fraud, online forgery, online hate, cyber stalking, etc. These are different offenses or crimes, and in certain countries the criminal code has been appropriately amended and these offenses have been properly defined in such laws. On the other hand, there are countries where cybercrime laws are not in place as yet. So there the traditional laws are still being made use of, although the need is that there should be full-fledged criminal laws available that deal with these novel type of offenses or crimes. So that is all for our today's lecture. In fact, today is our last lecture. And I hope that you have benefited from this course. In fact, we have tried to study various facets or aspects of electronic commerce from technology point of view, from business point of view, and from law and policy angle. And I sincerely hope that you would make use of this knowledge to enhance your professional growth. And in the end, I would just say that wherever you are, whatever you do, be true Pakistani, believe in yourselves, and remember that education is the main thing that can drive us ahead. If we want to be a strong nation, the community of world, we have to really strive, and education is one thing where our maximum focus be at. So with that, Allah Hafiz.